The Senzo Meyiwa murder trial has been postponed to the 12th of July. It's to give accused number 5's defense advocate Zandile Mshololo more time to study the second docket. The document is said to implicate singer Kelly Khumalo and 6 others who were inside the Vosloorus home at the time that the Bafana Bafana captain was gunned down in 2014. 5 men are currently in court for their alleged role in what's claimed to be a robbery gone wrong. Judge Tshifhiwa Maumela announced the postponement following 2 days of debate on the second docket.
This case is postponed with the accused in custody to the 12th of July 2022 for purposes of argument around the issue of the second docket, as will have been ignited by the heads that shall be submitted by the parties in dates that were.
Well, let's unpack today's proceedings. We're joined by reporter Mnisi and Black Lawyers Association President Advocate Bayethe Maswazi. Good evening to both of you. Thanks for your time. Linda, let me perhaps kick it off with you so you can give us a roundup of what happened in court. It's really been a tense couple of days, and a lot of it centering on this second docket. As you heard now, Minister Ronald Lamola not wanting to be drawn on anything that has taken place in that trial, but it's something that ultimately the NPA is also going to have to respond to.
Absolutely, and when the media in fact approached the NPA, they couldn't give us any comment, saying the matter is sub judice, the same as the minister. Even the police not wanting to make any comment regarding that particular docket. But you would have heard then that Advocate Mshololo did manage to secure a response from the NPA in terms of where exactly, what exactly the status of this particular docket is. But, you know, we got through a lot of revelations today and a lot of, you know, explosive revelations being made, of course, by, you know, Advocate Malisalate, for one being the fact that despite the state claiming that it only got that docket last week, Wednesday, Advocate Malisalate says it had been in possession of that docket since January 2020, also revealing around the warrant of arrest. You'll remember the accused in this matter were arrested in October 2020, saying that in fact there were 6 people who were supposed to be arrested, and one of those was Kelly Khumalo. Let's take a listen.
In essence, at the time, was those warrant of arrest, according to those people who arrested them, they were arrested on the 26th of October 2020. And 6 people, not 5 people, were supposed to be arrested. And for the reason unknown, the 6th person's warrant of arrest was no longer executed. And the 6th person, according to the case docket 375, is accused number 2, Kelly Khumalo, in the 375. But here, it has been made that Kelly Khumalo could have been arrested together with 5 accused on the 26th of October 2020 for conspiring, murder, conspiracy to murder, and the murder of Senzo Meyiwa. So what made my learned colleague, Advocate Zandile, to hold back the warrant of arrest of Kelly Khumalo, which was prepared the same time with the warrant that were used to arrest our client here, the 5 accused before this court.
All right, so that's Advocate Malisalate for there addressing the issue around the warrant of arrest that was not executed and seeking, of course, clarity on why. But some of the explosive stuff, Kathy, that came out of the court had to be dealt with by the state, raising an objection saying that everything that Advocate Malisalate was bringing to the court today was from the bar and was not done procedurally. So he could not go further than just making those statements. So you'll remember that if he wanted to introduce an affidavit, he'd have to bring that particular witness who will confirm that affidavit and, of course, authenticate it. But he did not do that, and that is why we saw, yet again, a heated exchange between the judge as well as Advocate Zandile.
I'm starting to think they actually enjoy these little tit-for-tats that are taking place in the courtroom.
Yeah, and it's also because, when you look at previously, some of the applications that have been brought by Advocate Zandile, you'll remember the issue around 1010, the production house. There's been a number of other issues that the Advocate Zandile has brought before the court, but oftentimes we see the judge ruling against him, and it seems at the heart of this are the issues around procedures. If he wants to bring an application, obviously a notice of motion and affidavits.
In fact, I'm going to bring in Advocate Maswazi here. Advocate Maswazi, good evening to you. Just on that issue of procedure, is something that has come up before, and I think yesterday and today has been quite, predominant in terms of the reaction that comes from Judge Maumela, who's presiding over this matter. When you look at it, I mean, are there basic things here that are not being done according to the book?
Thank you, Kathy, and good evening to your viewers. It does seem that the evidence on the basis of which Advocate Tshifhiwa was arguing in relation to the details about the two dockets was not evidence that has been put before court. It was evidence original to himself, and obviously that is unprocedural. Counsel arguing a matter before court is not entitled to lead evidence from where he stands. He must put the evidence before court either by way of an affidavit or through a witness. And that is where the whole problem arose with the judge ruling against him in the matter.
When we look at the state and how they responded yesterday to this issue of the second docket, they're trying to suppress it, and one gets a sense that they wanted to kind of go away as quickly as possible, but it's not looking to be the case.
Clearly, and it's not going to go away that easily. Remember that in South Africa, an accused person comes before court because the NPA has actually decided to prosecute him. So if there are now two dockets, all at variance with each other in terms of the contents of who must be prosecuted, that obviously calls for an explanation on the part of the NPA to say what decision is actually the official decision. Is it the one contained in the docket that on the basis of which the proceedings are continuing? Or is it the different docket that has now since been introduced into the proceedings? All of this, in my view, would be call for an explanation on the part of the NPA, even in evidence, to call witnesses to show that this is the official docket and this one was just an official, an internal communication within the NPA.
All right. Linda, what are we expecting when this case resumes in July?
Okay, so you'll remember that before, in fact, after Advocate Mshololo asked for the postponement, Advocate Zandile therefore objected to that postponement, saying that it would prejudice his clients, given the fact that some of them, accused 1 and 2, were outside at the time of their arrest. He's also brought issues around the jurisdiction. So now the expectation is that he will bring an official application to the court, and all the papers will be furnished during this time and July. So when they come back in July, they'll be arguing, of course, the issue around jurisdiction, which is one of the issues that, the minister is said to have not dealt with in this particular matter. So Advocate Zandile therefore believes that this particular matter should not even be sitting in Pretoria. He believes his clients were in fact kidnapped from Johannesburg to Pretoria. So when they come back on the 12th of July, they'll be arguing the issue of jurisdiction. And then on the 5th of September, we're expecting then the trial to continue with cross-examination, Advocate Mshololo looking into that second docket.
Advocate Maswazi, let me bring you in here. You know, there are lots of questions being asked about the future of this case. From a legal point of view, and I want you maybe to take a bit of a slant view and put yourself in the shoes of those that are representing the accused in this matter. Are there prospects of success if they were to try and get this case thrown out of court, given the bungle that has been created here over the evidence that's before the court?
Well, and not being aware of the information that they have before them in detail, but I would say that our law requires that once an accused person has pleaded, the trial must proceed and he becomes entitled to a verdict either of guilt or not guilt. So if that is likely to happen, it might happen perhaps as a way of an application under Section 174, where the defense, after the state has closed its case, will then apply on the basis of the information that they now have before them to demonstrate that there is no case against the accused.
So as
but I do not foresee an instance where the case is thrown out of court midstream without those remedies having been exhausted and traversed up to a conclusion.
All right. Black Lawyers Association President, Advocate Bayethe Maswazi, and our reporter, Linda Mnisi, who's been keeping up to track with all of the ups and downs, the ebbs and flows of that court case that has taken place in the North Gauteng High Court, rather.